appeal it to city council, but if you appeal it, then they're fine. But on actually.
All right, I believe we are ready to call this meeting to order.
Chair Templeton,
Present.
Vice Chair Rupavar,
Present.
Commissioner Awcheck, Commissioner Heckman,
Present.
Commissioner Lowey,
Present.
Commissioner Riggs,
Present.
Commissioner Suma. Thank you.
So shall we start with the director's report, or any changes to the agenda that we need to know about? No?
There are no changes to the agenda.
Great.
I'm not sure if there's anyone here for the oral communications that's on items not on the agenda.
If you have anyone here that is speaking to an item not on the agenda, now's the time. We do have cards for those that have submitted them for agendized items, but nothing for, okay. So let's move on. And are you ready for the director's report? Okay, great.
Good evening, Commissioner Templeton, Vice Chair Rupavar. Sorry, I gotta get my new phrasings right. Chair Templeton, Vice Chair Rupavar, and rest of the Planning and Transportation Commissioners, good evening. It's good to be with you here today. A couple updates. Just looking back to Monday, the City Council had an agendized item, which was discussion of Councilmember Du Bois and Cormac's report on looking at our boards and commissions overall in the city. One of the proposals, if you did read their report, was potentially to split the Planning and Transportation Commission into two commissions. That was discussed, and I believe most of the council members did not support that move, wanted to keep planning and transportation together as they are very linked items, and we're one of the cities that's fortunate to have those two items be in the same commission, and so we really can think about them together. So I don't believe that portion will be going forward. There were a couple of recommendations, including trying to align the application period to once a year so that there could hopefully be some efficiencies in making sure that all the boards and commissions have their vacancies filled in a kind of maybe a more streamlined manner, as well as discussion about some handbooks, some other ways to make sure that commissioners have what they need when they start, and that chairs and vice chairs also have perhaps training, other resources available to them. So we'll look forward to seeing more from Councilmember Cormack and Du Bois there, and an ad hoc committee on this topic, and we'll try to keep you abreast of anything that would affect the Planning and Transportation Commission especially. And then I should say Commissioner Lowing and Chair Templeton were there as well. They may have any insight that they want to share from Monday's meeting. I don't know if anything sticks out beyond what I have shared on that topic. Okay, great. Tomorrow, looking ahead to tomorrow, we have a public workshop and open house on the North Ventura Coordinated Area Plan. That will be from 6 to 9 p.m. at Gunn High School in the new Student Activity Center there, room 115 and 116. We're also combining with the Bulware Park open house. So Bulware Park, you may be aware, the city purchased additional property adjacent to Bulware Park and is looking at expanding that and the design improvements for that. So it's great to make sure that people can come out and come to one meeting and be able to discuss both topics, especially since the NVCAP area and the park are very adjacent, so it's a good use of resources. We also were fortunate as a city to be recipients of what's called a challenge grant. So the Partnership for the Bay's Future, which is a consortium of funders, including corporate philanthropy, as well as San Francisco Foundation, Silicon Valley Community Foundation, other foundations, has put together a pot of money, and a lot of the money is for the construction and preservation of affordable housing. They also have a policy fund that is really focused on, as it sounds, policies, and they've taken up as their first set of policies they want to promote at the local level to be policies to help protect renters who are currently in place. That's something that a couple years ago the City Council had brought forward a colleagues memo to ask the Planning and Development Services Department to look more at what could we do to help protect our renters here in Palo Alto. We applied for this grant last fall and were successfully awarded this grant along with 6 other jurisdictions, so 7 total, including our neighbors East Palo Alto and Redwood City. So we're really excited to join this cohort. Part of what the grant is not for funds that go directly to the city, but a mid-career fellow who will be with us for 2 years, and she will start with us in a few weeks. So we're very excited to have her on board. We also have a community partner, which is Silicon Valley at Home, that we'll be working with, that has a lot of great policy expertise. We'll also be working with PolicyLink as part of this. So they're really bringing together a lot of players to try to make sure we have resources to help understand the data around who rents in our community, what are the challenges that they face, and what are the things that we can do from a policy level as a city to help support those folks. So her work will be underway very soon, and we're really excited. Hopefully you'll be seeing some things come to PTC in the next few months. And then lastly, we of course seem to be perpetually hiring at the Planning and Development Services Department. We currently have openings for 2 code enforcement officers, so we're looking forward to filling those, making sure that if people are violating our municipal code, we can be sure to be attentive to that and to the requests people have. We currently only have 1 of the 3 positions filled, and so we're looking to fill the 2 others. We also hopefully will be sharing with you soon openings that we have in our long-range planning team. We have, of course, our planning manager, who was formerly Elena Lee, who may have come here before related to NVCAP, or her very long suffering project, the comprehensive plan. She led that. So that her position is open, as well as Hung Nguyen, who had the housing manager or housing planner position, that's open, and a principal planning position. So we'll have those openings. So if you know folks who are great planners, who you want to have in the city of Palo Alto, please pass that on once we have those positions posted. Should be hopefully before the end of this week. And so that's the director's report. Thank you.
Excellent, thank you so much. And to all my fellow commissioners, I highly recommend, if you can, attend the NVCAP meeting tomorrow. The presentation itself is just 6:30 to 7 at Gunn, so it's not a huge time commitment, but it'd be very important to be as informed as you can on this, very large site that's under discussion. So, all right, yes.
Do you know if it's like televised or anything?
Will it be recorded?
I do not believe it will be recorded. We can record the presentation at least, because it's an open house format, and so most of it will be people at stations interacting, so it's a little difficult to record that, but I can see if we can record at least the presentation portion.
All right, thank you. Commissioner Riggs?
Thank you, Chair Templeton. I have 2 things, 2 questions. First off, thanks for sending the ad for I think it's a code enforcement earlier. If you could just make sure you send us the ads, I can make sure they go to some of the alumni boards for the planning departments particularly. And then the second thing, with a partnership for the Bay's Future funds, will there be items that you expect that will come to us, policy items that you think will come to us based on that work effort?
Yes, what we anticipate, I anticipate there will be items that would come to the PTC. Part of what we are really wanting to do is make sure we first focus and understand who the renters are in Palo Alto and what would be the policies that would be most effective for them. I know some other cities with this grant are looking at more legislative changes, but others are looking at more programmatic solutions that they may offer, and so it kind of depends what solutions we do first. But again, this person will be here for 2 years, so I imagine that some of the solutions we'll put forward will be policy solutions that would come to PTC for input before going to council.
But after once we have the personnel, the person and staff, we don't have any other funding relationship with the partnership with the Bay's Future.
Well, I hope it opens the door to continued and beginning funding relationship with them. So my understanding is that this is the first round of this type of grant funding that they're offering. They may have future rounds of funding for either related or different policy items or different policy topics. So I hope that we would continue to be able to be competitive for more funding in the future.
All right, thank you so much. Let's move on to agenda item number 2. Is there any public comment on this? I guess we should do the presentation, then take the public comment if there is any. Okay, kick it off, please. Thank you.
So Tim Shimizu from our City Attorney's Office is going to be presenting on this item.
Thank you. Good evening, Chairperson Templeton and Honorable Commissioners. My name is Tim Shimizu from the City Attorney's Office. I work with Sandy, my wonderful colleague. And I'm here tonight to ask that the PTC recommend that the City Council adopt the proposed ordinance, which you have in your packet as Attachment A, to update 5 sections of Title 18, which is the city's zoning code, related to enforcement, hearing procedures, and to reflect the new name of the Planning and Development Services Department. So if I may, I will briefly run through the 5 changes and then take any questions or comments you may have after that. So jumping right into section 18.01.080, this is the city's charging section for Title 18 violations of zoning. And this language has been updated to true up with the recent passage of the building codes that live in Title 16 for things like building, fire protection, and so on, so that the language is the same, because many times the zoning and building are, they're violated at the same time, unfortunately. And so just to make it very clear and consistent about what the language is, this language mainly is a clarification. The existing language cites that violations are misdemeanors, which ignores the city's administrative procedure, which lives somewhere else in the code. And so we just wanted to make this clarification in part to clarify and remind both staff and the public that the city can enforce Title 18 by both administrative remedies, which is the more common method actually today, in addition to the criminal remedies that also exist. And again, so that's 080. Next is section 085, and this is the Criminal Enforcement Authority. And so what this section does is that under state law, cities can adopt ordinances which authorize non-police officers or non-law enforcement people to enforce certain city laws as criminal acts. And so while I just said that is rare, the city currently already has that authorization. And so this clarifies this to update the positions that are empowered to do that to the chief building official and the code enforcement officers. The existing language has a position that either no longer exists or no longer is really in that capacity. The next section change is 1804.030, which is the definition of the director. And this just updates the name of the director to the Director of the Department of Planning and Development Services. The next section, 1840.170, relates to in cases in which the director can defer his or her decision, go straight to council. And in this update, we're allowing in those cases, the director may seek or refer the item for recommendation to the ARB or PTC, when in the past this may not have been available or may have only been available on appeal. It also updates the categories of projects that may be referred to the City Council to include those that require a statement of overriding considerations under CEQA, and that's typically in a EIR situation. Lastly, 1877.060 talks about, has a phrase that says there is no fee for requesting a hearing. And this language was inconsistent with the City Council directive that planning applications be administered on a cost recovery basis. So as the staff report says, while the city doesn't charge a fee for merely requesting the hearing, it does hold the project applicant responsible for the costs incurred by the city in holding a hearing on the project. And so this is the status quo, but we just wanted to clarify that because sometimes the person requesting the hearing is also the applicant, that they still are on the hook for those fees. And so those are the 5 section changes, and I welcome any questions or comments at this time.
All right, commissioners, please press your lights if you have any comments. All right, Commissioner Heckman, followed by Commissioner Alchek.
Thank you, and thank you for the report. Just a quick question on the change to 18.01.080. In the first paragraph, line 4, after the word code, there's a semicolon that I think should be a comma. And I'm wondering if that can be corrected, or does that have to stay the same as a semicolon in these 2 other provisions elsewhere in the code that you mentioned?
Can you repeat the section again? The line?
It's the first one in the ordinance, 18.01.080.
Line 4.
4th line of the first paragraph. So chapters 1.12 and 116 of this code, I think should be comma in criminal enforcement. Is that, does that stay the same, or?
So I think that's a change we can make. So I'll look into just making sure that that's, for some reason, that's not how, for example, lists in this entire section work, or this entire chapter work, but there's no particular reason why that has to be a semicolon versus something else.
comment. Thank you, Madam Chair. So we don't have to retain it for consistency with other sections. However, it is our standard practice when there is a colon and a list after it to use semicolons between each item. Now here we only have 2 items, so that's kind of unusual, but that's typically how we handle it.
The continuing education of a young PTC commissioner. Thank you.
I think we all learned something from that conversation, so thank you. Commissioner Alchek.
Thank you. So a few comments. The language that's recommended on packet page 9, the third paragraph under 18.01.080, when the code enforcement officer determines, et cetera, et cetera, et cetera, when the violation has been corrected, the code enforcement officer shall issue and record a release of the notice of pendency of code violation. I would suggest that we recommend council add the language within 10 business days or within 14 days. I think when you're recording notices in the office of the county recorder, we should be very vigilant about the releasing those notices, those recordings, as quickly as possible once they're remedied. And I think that if you don't like the timing I'm suggesting, I think you should still consider some time frame, because the failure to include a time frame will absolutely lead to some explosion at some point. Somebody will be like, they never did it, and you want to give some clarity there. And so if you're uncomfortable with 10 business days or 14 days in general, choose a time frame. I think give council that additional language and at least explain why that time frame makes sense to you. The next suggestion I have, packet page 10, section 5, or I guess is that, it's, this is the open parens for, close parens, any party, that paragraph there. Do you see that? Sort of the third paragraph from the bottom. Mm-hmm. Any party, including the applicant, may request a hearing of the Planning and Transportation Commission on the proposed director's decision by filing a written request with the Planning Division. I think you should add language that explains how you would file a hearing request and the timing of such request, like how soon it would need to be filed. And if, for example, there is another section of the code that deals with these sorts of requests, then you should put language in this paragraph that refers to it. So something to the effect of such hearing requests can be made in accordance with sections, whatever it is that details how hearing requests are implemented. There's sort of a number of different things that can happen in the course of, let's say, an applicant's experience, and I feel like there's some ambiguity on how you file these hearings, what the time frame is. For example, does the city have to schedule that PTC hearing on the director's request within 30 days, 45 days, 6 months? And I think it would sort of behoove us if we just made it clear. It's possible there's a whole section about this process, but if there is, we should refer to it in this section, and so that we're not hunting through the code. And then, no, that's it. Thank you. I'm sorry.
No, thank you very much. Any other commissioners? Oh, it looks like Vice Chair Rupivar and then Commissioner Suma.
So I don't have an issue with the language as written. I did bring this up in our pre-commission hearing, which was section 1801.085, which refers to California Penal Code section 836.5. And my understanding is standard operating procedure has been that pursuant to that code provision, Planning and Transportation can or has been issuing criminal citations. I don't think that that practice is correct. I did want to point it out. I do believe it's overreaching, because when you look at the actual code section, 836.5, it says that a public officer or employee, when authorized by ordinance, may arrest a person without a warrant whenever the officer or employee has reasonable cause to believe that the person to be arrested has committed a misdemeanor in the presence of the officer or employee that is in violation of a statute or an ordinance that the officer or employee has a duty to enforce. So the corollary to that is is California Penal Code Section 837, which allows for criminal arrests as well. From the plain language of the statute and reading of it, that appears to only authorize arrests for misdemeanors created, done in the presence of those two building officials, employees. So I wanted to just point that out again, that I do believe it'd be overreaching for our chief building official and code enforcement officer to be issuing criminal citations. That doesn't impact, their ability to refer to the city attorney's office or allow law enforcement or an attorney to do that. But plain language says that, and we don't see with citizens that code section relating to citizens, for citizens arrest, issuing criminal citations. That's my only point. It doesn't impact the language, but I did want to kind of speak to that because, or if you want to explain it further to me, but that was my take on that.
Madam Chair, may I speak to that? Thank you.
Yes, please do.
Thank you. So Penal Code 836.5, which is referenced in that section, does further say that the employee making the arrest can prepare a written notice to appear and release the person on his or her promise to appear. And so that is colloquially known as issuing a citation. So that is pretty common, where an authorized officer, rather than bringing someone in to be booked as part of an arrest, will issue a citation, which the individual signs with a promise to appear at a certain time and place in the Superior Court. This is a long-standing provision in our code, and I know in many other codes where certain employees, other than police officers, are authorized to issue criminal citations. It is done extremely rarely, and I don't know if anyone can even recall when the last time a City of Palo Alto code enforcement officer may have done so. However, when these incidents occur, usually it's one of these individuals who has witnessed the occurrence, and so that crime would have occurred in the presence of the issuing officer.
All right. Any other comments, Vice Chair? All right. Thank you very much. Commissioner Suma?
Thank you very much. I appreciate the comments made so far, especially Commissioner Olczyk's suggestion that you refer to or put the actual procedure for doing an appeal in that section, or at least refer to it, because I found myself going back and forth a lot. I also found myself with two of these things, and that's a section we've just been talking about, 1801050 and 1840170. Are those just cleanups for consistency with the building code or state law, or are do those have other policy implications?
Just to be clear, the first one you said was 080, the very first one.
1801085.
Oh,
the
yeah,
enforcement one we've just been talking about.
So 085 is the only change that's being made besides just clarification is to update one of the positions that was in existing law no longer exists or is no longer used in practice. And so we swapped that one out and put in code enforcement officer, which is the main employee job title that does code enforcement.
Okay, so that's the plan check engineer no longer exists?
If that person no longer really does, I don't know if they exist, but they don't do code enforcement. Like they're not out in the field doing that.
So these, I was really confused by this. There wasn't a lot of context for me for some of these changes. So this is not to say that we don't have building inspectors that enforce the building code. This is just when a citation rises to a criminal. Okay, that clears that up. And then with 1840170, deferral of director's action, I was wondering, you've added letter C here, projects requiring a statement of overriding considerations pursuant to section blah, blah. So why was that added? Were there some specific projects that triggered in the last year or two that triggered adding that, or is that also just a cleanup for consistency?
Okay, thank you, Madam Chair. So I don't think there were any projects that triggered it. However, this only arises when there is an EIR with significant and unavoidable impacts. So basically, when that exists, when we have prepared, the city has prepared an EIR, I can't think of an instance when that matter did not already go to council, anyway. But they're usually, significant community impacts may be at play. And so I think in those situations, the Director of Planning would like the opportunity to have potentially a further hearing with our advisory bodies to get more community input on those types of projects. So again, they're just projects with EIRs with significant and unavoidable impacts, and usually the statement of overriding considerations would be citing various policies of the city, and in those circumstances, we may want more than just the Director of Planning weighing in, getting some additional input from our advisory bodies.
So it allows for additional public hearing input?
Yes.
Okay, thank you for clarifying that.
All right, Commissioner Lowing.
Yes, just two things. One was actually right on that same thing. So I'll start from the bottom of my intended comments, but for the same reason, that's why I thought C was kind of redundant. Because if it needs a statement of overriding considerations, that has to go to council. So I'm not sure why you would add that here.
Because technically, it doesn't have to, because
Really?
yes, the body that takes action on a CEQA document or the person is whoever's making the decision on the project. So in Palo Alto, most of our, actually, none of our boards and commissions make final decisions, so
Right.
those items would go before council.
Right.
However, sometimes the Director of Planning is the decision maker. Now, those projects tend to be smaller in scale. However, if there was an EIR for a project within the director's authority, the director is the one who who would be able to take action on that document.
Okay, prediction, that's never going to happen.
I know, yes.
Therefore, it's
absolutely.
redundant.
Well, it's probably, extraneous.
Yeah, exactly.
Not redundant, but extraneous,
Okay,
yeah.
okay.
If I may add to what Sandy is saying, I think part of it is that it's adding, as she said previously, the ability to go to these other bodies prior to that. That's really the underlined part, that's the additional. So you're correct in that it already is going to go to council if it's an EIR, but this is saying before on its way, let's bring it to some other bodies. These forums are great for getting more community input and having another chance for the issue to be discussed before it goes to the city council.
Right, but the intent here is, as I understand it in this coverage, is to itemize when the director might choose to send it to council without making a decision. So he or she's already made that decision. It's fine, it's just, it's just one more line in the code, I don't want to argue about it. But just in terms of confusion to a common reader, not a land use attorney, you say here that the director shall have authority to forward projects to city council for final action, circumstances listed below. No action by the director shall be required. Well, it seems like the action was sending it to council. That was the action.
Yeah, the director doesn't have to make a decision. Okay. So we're competing to speak to that question. So this means that the director doesn't need to make a decision that's appealable. So instead of making the decision, the director can send the item to the Architectural Review Board or the Planning and Transportation Commission, and then on to council for a decision.
I just did the statement there, no action by the director shall be required. it is referred to no decision
Yes.
should be made. So maybe you put that in there.
Okay, I see what you're saying, yes.
Something like that.
Do you have a proposed wording, or does council have a proposed wording? If we're going to approve it,
Well, I think you were just saying, no decision will be made by the director, but it will be forwarded or something like that. I'm not even sure those words are needed, but
I guess what I might suggest, I think we all understand the tenor of what Commissioner Lowing is saying, and that we just be allowed to consider that putting in that language, drafting it, rather than doing it with the commission on the dais.
that sounds fine with me.
so we could approve it subject to attention to that section for clarity. And my other question is just kind of a related question is, the fee for having the hearing is approximately what, just out of information?
So I think it may vary by the item, but I know it's a deposit. So what happens is the fee is or the hearing is requested, let's say by someone who's appealing a decision, and then the project sponsor, the applicant, would be required to put in a fee. For example, a CUP earlier this year was appealed and the fee was $10,000, but that's what the department draws against for the staff time for the hearing, and it may be less than that ultimately, and then the balance would be refunded to the applicant.
Okay, thanks. No further.
Excellent. So the only thing that I would add is just, could you speak to the, so part of the goal in putting this before us was about the department change. Can you speak to the intentions that you have for changing the department name in other places that we might not be seeing?
So as the commission knows, the department name shows up in Title 18 and many other parts of the code in various forms. It can be Department of Planning and Department of Planning and Community Environment. And so to reduce having like 500 little pin sites before you, the city is going to, or the staff is proposing to council in March to, in the entire code, have all references to various iterations of planning, PCE, refer to the planning of planning and development services as an uncodified ordinance. So at least it's on paper that it's, for clarity's sake, if it ever comes up, it's always there that that's what it means. Instead of trying to fix every single section of Title 18 and other sections.
Great, thank you very much. Commissioner Olczyk?
I was just curious about the question that Commissioner Lang was asking. If the director decides not to make a decision, do they still put forth a recommendation on behalf of staff at the hearing? And is there, yeah, I'm just curious about that. I understand it. So like you're being put in a position to make a decision. I see the political strategy of just not really making that decision and deferring. I can also imagine a more interesting sort of setup where the director makes a decision, and if the council overturns him, the applicant doesn't have to actually pay for it. That would be, one improvement in my opinion. But no, I'm just curious, if the director decides not to make a decision, does that mean the director will also submit a staff report making a recommendation, in which case they put the time in to have an opinion? And I'm curious to know what the reasoning would be for not standing behind that recommendation.
Right, so, thinking of hypothetical cases, and which is obviously has its benefits and its challenges when we're thinking about what might happen. I can imagine to some degree, as you pointed out, this might be an instance where there's some type of controversy or it speaks to kind of some larger policy decision that the director may feel there has not been sufficient guidance from the council or PTC or the city overall. At the same time, perhaps the item has merit that would be worth bringing forward for consideration by this body, by the council, to kind of make a clear decision and provide direction. Oftentimes, our community has different opinions about what direction we should go, and so I think part of this is to respect the role that the council and even recommending and advisory bodies have in helping to think through these questions and to make a decision about the direction our community wants to go. Certainly, there would be a staff report that might outline pros and cons and kind of different ways to look at this, what our code says, analyses that we could provide, data, if there's any quantitative or qualitative data that we could provide. And certainly the director may have a professional opinion that they would provide, but perhaps it would stop short of a recommendation. Or it could come with a recommendation, or kind of here's all the information and here's what the director is thinking. Do we want to move forward with that recommendation, or is in this case, the PTC, or was to the city council, would they have a different direction?
So I have a question for you. If, for example, a director made a decision and it was appealed by someone other than the applicant, does the applicant pay the bill?
Yes.
Okay.
Any more thoughts? Okay. All right. Entertaining motions. All right, Commissioner Lowing.
I'd move the staff motion with the exception that we would expect to see some improved language in 1840.170, referencing decision-making taken by the director. But I would also like, okay, first let's get a second.
Is there a second? Dorian, Commissioner Suma?
I just wanted to ask if Commissioner Alczek's comments are sufficiently incorporated by the motion that I made.
I had two very specific comments about language. One about releasing records that are sort of recorded by the county, right? Adding that time period, and also improving the section about appeals with some information regarding how that process would take place and the time frame for that process. Are those the comments you're referring to?
Yes.
Yeah.
I'm happy to incorporate that in the motion unless there's objection from council.
That would be great.
Thank you, Madam Chair. We did not respond to Commissioner Alczek's comment about the appeal process. There are other sections that actually detail the time frame for how much time before an appeal can be filed, and the time frame in which an appeal hearing has to be scheduled. So those provisions are in there. We certainly can go back and look at the section to see whether we should be referencing that section. I don't have it right in front of me, but we can certainly do that. But the information is actually in that chapter. And then with respect to the timing of the recording or removal of the notice of pendency of action, so we don't really have enough information right now to know if 10 to 14 days is going to be adequate for staff to manage that. I would just say that the language that is in there is very similar to language in the government code with respect to zoning ordinance violations, as well as the Code of Civil Procedures with respect to other code violations, neither of which has a specific time frame for recording or removing the notice of pendency. We certainly can look into what an appropriate time frame could be.
Do you record zoning violations in the county?
I doubt it's done with any frequency.
Yeah.
I happen to be working on one from 1965.
That got recorded.
That was recorded.
This is exactly my point. Actually, this is exactly my point, is that if we don't specifically outline how to remove these recordings, they get left on there in perpetuity. And my point isn't that it has to be 10 to 14 days. My suggestion, my recommendation is that council consider language that specifies a time frame by which they would get removed. If the 10 to 14 is not suitable in staff's mind, then whatever time frame staff was comfortable with the justification for that comfort level. So maybe it's 30 days, but
Commissioner Rubar has a
that was
comment?
my suggestion at the time.
Vice Chair?
Yeah, for whatever it's worth, on the lit side, there are notice of pendencies of action, lis pendants that are filed, and there are statutorily mandated periods of time in which those need to be removed from the recorder's office after a case concludes or a final decision is made. If it might help, that might be a reference point to look at to see what the CCP says in terms of removal of lis pendants and apply the same time period,
I mean, look,
if it's helpful.
we don't need to have the language as a part of the motion, but I think you understand sort of the premise,
Yes.
and if that can be communicated in such a way, just to make this tighter, I think it will be an improvement, but I don't want to complicate the motion.
We'll certainly look at that, Commissioner Alcheck and Commissioner Rupert.
Okay, so I'm hearing that additional language is not part of the motion. So it's just my original motion, which references the 1840-170.
Okay. Before we take a vote, I just want to double check. We did ask for public comment, right?
Did.
We did not yet.
So we should do that before we vote.
We should do that. And then we can clarify the motion after to make sure I have the notes right.
Thank you. Did anyone have a public comment? Okay. No, we don't have any here. Yeah. Okay. Thank you. You can proceed. Did you want to read it back?
What I have is the motion is to move the report and the proposed changes forward with clarification in 18.40.170 regarding the no decision by director to clarify that language. Is that, and that does not include the time frame suggestion from Commissioner Alcheck, and that does not include referencing the appeals section in, what part is that? Not referencing the appeals section in, I guess it's section 5.
And I trust you'll follow up on that and make sure you feel it's adequate afterwards. You have our feedback on that. Okay. All right. Are we ready to vote? All in favor? All opposed? I'm sorry, Commissioner Riggs, I couldn't see your vote. Oh, okay. All right. So it's 7-0. It's approved. Thank you.
Thank you, Commissioner, and thank you for your feedback.
Yes. Thank you very much, Mr. Shimizu, for presenting.
Great, thank you.
Okay, we're going to move on to item 3, and there's a lot of moving parts in this item. I believe the first step is for us to deal with disclosures. So we'll go down the line, starting with Commissioner Riggs for any contacts on these matters, including meetings, conversations with individuals, site visits, mailings or presentations where substantial factual information was obtained by the commissioner. We'll disclose any contact in which the commissioner learned new and pertinent information that's not part of the public record, explain the nature of the contact and the substance of the information learned. Contacts and receipt of information prior to the PTC meeting is not by itself grounds for disqualification unless they have affected your ability to make an impartial decision. So you may have engaged with the participants in this discussion, but it may not be disqualifying. So just speak to your engagement.
Yeah.
Huh?
Yeah, so the applicant called me to try to schedule a site visit, but I declined.
I met with the applicant of 840 Kipling and reviewed plans and took a site tour.
So the applicant emailed me to schedule a site visit. I met with them, reviewed plans, took a tour. I learned information about trenching on the two neighbors side that impacted the tree growth, but I do believe that that's included on sheet T2, but I did want to point that out.
Thank you. I have not had any contact with the participants in this hearing.
I met with the applicants at 840 Kipling, had them explain to me some of the information that's in the staff report and the associated documents, so that's already part of the record, and did walk the site with them and looked at a couple of trees in the neighborhood that are referenced in the site report. In the record.
I also met with the applicant at 840 Kipling at their home and looked at the plans and associated documents and did a site tour.
Thank you, and brief hold while we seek our last input. All right, sorry about that. Commissioner Olczak, you're on for disclosures.
I met with the, I guess, Reina family, if I'm pronouncing it correctly, of 840 Kipling yesterday. They walked me through many of the comments they made in the letters. I don't believe they shared any information with me that wasn't already in the packet, and I asked them that same question, and they confirmed that. So other than that meeting, I have nothing else to disclose.
Great, thank you. And just to check in with our legal team, do we feel comfortable proceeding with no recusals?
Yes, Madam Chair.
Thank you very much. All right. So I have the order of operations here. Please hold. Vice Chair to the rescue. Thank you so much. All right. So the way we're going to proceed through this is we will start with a staff report, and then we'll hear from the hearing requester for 15 minutes and the applicant for 15 minutes. After that, we will do public comment, and I have the cards here, but if there's anyone who has not filled out a public comment card, please hand them into that box behind Ms. French. All right, and then the hearing requester and applicant will each have a 3-minute rebuttal after public comment in case there's topics that come up that you'd like to address, and then the commission will discuss. All right, thank you very much.
So Commissioners, I want to introduce Christy Fong, who will be doing our staff report this evening. Christy has over 9 years of planning experience, including subdivisions, long-range planning, current planning, and she began her planning career in Canada. But we were very happy to have her working on this project. As you have seen in the project history, this project's been underway for some time, and so we are happy to be bringing it before you for its next phase. Hand it over to Christy. Thank you.
Thank you for the introduction and good evening, board member. I'm the project planner for the proposed project locating at 840 Kipling Street. So just to give you some history on the project is presented to the PTC tonight in response to a hearing request made by a neighbor residing at 441 Channing Avenue. This project involves an individual review and a variance application at 840 Kipling Street when the project was first submitted in 2018. Since this property is a historic resource, the Historic Review Board reviewed this project on February and December of last year for its consistency with the Secretary of Interior standard. Upon review, the Director of Planning and Development Services determined that the project is in conformance with the applicable zoning requirements and tentatively approved the project, which is the individual review and the variance applications on January 15 of this year. A timely hearing request was received from the neighbors at 441 Channing Avenue on the tentative decision. PTC is the reviewing body for the variance after the director has issued a tentative decision. Your recommendations will be forwarded to the City Council for final decision. For tonight's agenda, the PTC will review the project, conduct a public hearing, receive public testimony, and provide recommendation to City Council on the variance request for 840 Kipling Street. The variance requests include a second-story additions to a historic resource on a substandard, irregular R2 zone lot, a 6-foot extensions to a non-compliant wall, which is currently encroaching 2.5 feet into the required 6-foot required side yard setback on the west elevation. Just to give you some information on the context of where the project site is, 840 Kipling Street is located at the southwest corner of Kipling Street and Channing Avenue in the South of Forest area, coordinate area plan phase 1, SOFA Cap 1. The project site is zoned as R2, two-family residential, surrounded by single-family, no density, and multifamily residential uses. The area north and west of the site are zoned as R2, and the area east to the site is zoned as DHS, detached housing on small lot. It is a special zoning district created by SOFA Cap 1. The hearing requester is located at 441 Channing, which is on the left side of the subject property. 836 Kipling is a substandard lot with a smaller one-story home that is located on the left side of the subject property. The project is located on a long rectangular-shaped substandard lot. This lot is considered substandard because it does not meet the minimum lot requirement in the R2 zone district. The subject area has a width of 39.5 feet, where the minimum width for a regular lot in the R2 zone district is 50 feet. The lot area for this project site is 4,893 square feet, where the minimum lot requirement for a standard lot in a R2 zone district is 4,980 square feet. The existing property has a 1,192 square feet single-family residence with a one-car detached garage at the back. The main residence is a single-story bungalow with an attic that was constructed in 1912. This residence was previously determined by the Historic Review Board as a contributing residence, as it retained historic merit. So this diagram is to provide you some information on the project. The project involves an individual review and variance application for a 184 square feet ground floor addition at the rear part of the residence, a 397 square feet of partial basement beneath the rear addition, and a 489 square feet of second floor addition. The project site has 2 protected trees. They are redwood by the property line at the back, which share a tree protection zone of 35 feet in radius from the tree location. The tree protection zone limits part of the buildable area by the rear side of the property. The need to maintain this tree protection zone from further intrusion qualify this project site as unique and is eligible to request for a variance. The PTC review for this project is to 2 proposed variance requests, which includes the height and the side yard setback encroachment. There are 2 zoning regulation restrict development on substandard lot with 1 habitable floor at a maximum height of 17 feet. The proposed project includes a second-story additions, and the proposed height will be 26 feet 8 inches that will require a height variance. The existing main residence is a long-compliant facility with a wall on the west elevation that is located 2.5 feet into the required side yard setback. The project would extend approximately 6 feet to the rear part of the home, which would not be visible from the street. These requests would normally fit within the specific limit set forward in the home improvement exemption that would allow a legal non-conforming wall building that is located 3.5 feet from the side property line to be extended up to a quarter of the length of the existing wall or 10 feet horizontally, whichever is lesser. To clarify on the point that we state in the staff report at packet page 18, because this project would alter just about 25% of the existing wall, and it become ineligible to request for a home improvement exception. As noted above, the subject property presents limitations for ground floor expansion. The PTC can review the project, assess the property conditions, and determine whether the project will meet the 4 findings for granting of a variance. This is the genetic findings that is in our code right now. Proposed finding on the tentative decision is presented in packet page 46 in the staff report. In summary, staff found that the 35 feet tree protection zone for the 2 protected redwood tree on site will restrict the subject property to expand on the ground floor. When such expansion is allowed in the R2 zone district for a substandard lot. The project with the granting of the request height, side setback variance, would not affect the project's compliance with other R2 zone development standards. The project meets the individual review guidelines and also meets the Secretary of Interior standards for rehabilitation. The project is generally consistent with the goal and policy identified in the comprehensive plan and in SOFA Cap 1. The proposed second-story addition will be built within the required building envelope, and the proposed extension to the first floor wall to an existing non-complying wall is appropriate in scale and would not reduce the current side setback. At last, the proposed additions were not found detrimental and would not pose potential risk to public health, safety, general welfare, or convenience. PTC can assess whether the current project will meet the 4 findings for variance, and staff will forward your recommendation to City Council on consent calendar. The hearing requesters had also requested for a director hearing for the individual review application, which is scheduled for March 5th, 2020. If the director hearing decision is appealed, the individual review application will be placed on the same consent calendar with the variance. And that concludes staff presentation.
Thank you very much. All right, so let's move on to the hearing requester, and Vice Chair, please set for 15 minutes.
Pardon?
Did you have a presentation? No.
No, unfortunately, everything's printed, but I think you all have it. It's that. So pardon me for starting so rudely, but Chair Templeton and Commissioners, good evening. My name's Charlie Bernitsky, and I'm here today representing Sander Gubbins and Karen Hahn. They own 441 Channing, which is right next door to 840 Kipling. My apology that it's paper. I usually don't do paper, but I just had a minor technology explosion today, so I hope you'll forgive me for that. What we're going to talk about today really is whether or not a variance should be granted to build a second story at 840 Kipling. And the critical thing that I'm going to ask you to remember is that variances are rare and exceptional. My background, real estate land use lawyer for 33 years. I live in Foster City, 4 years on its planning commission, 9 years on its city council. I think in all those years and all those capacities, I've done 6 variance requests. And the reason that variances are unusual and exceptional is because you're asking someone to make an exception to the law. So the law in this case would say that the property owner at 840 Kipling cannot build a second story. And why is that? Because it's a substandard lot. There's no dispute. The applicant agrees with that. The city agrees with that. We agree with that. And so the issue is whether or not there's something about this particular property that allows for a variance. And it should be exceptional, because otherwise the reliance on the rule of law dissolves into chaos. And what I'm going to talk about today is that there is nothing exceptional that would allow for the granting of a variance in this case. So let's, if you wouldn't mind, let's turn to the second page. This is from your packet 20, page 12. And it talks mostly about things we agree with. And on the first section, it says that because the lot is substandard, the law in Palo Alto is that development is limited to one habitable floor with a maximum height of 17 feet. And as we saw, the house is already 18 feet. The next paragraph talks about extending an existing non-conforming wall. But what I mostly want to draw your attention to is the third paragraph here, which staff says there's really two reasons to grant a variance. One is the tree in the rear yard and the need for a 35-foot tree protection zone, and the other is the odd shape of the lot. I'd also like to note that there's kind of an anomaly here in that, and I'll show you the numbers as I go through this. If the law were just applied, the largest house that could be built on that would be a little over 1,900 square feet. But if you then grant a variance, there's an additional several hundred square feet that's allowed. So not only is this lot the proposal is to build this lot to a second story, which isn't allowed, but to a greater extent than what would be allowed if the law was applied and it was only limited to 1,900 feet. So I know on the bottom it says 64%, but that's my hopefully only other mistake. It should be 57%. I think I corrected it in the other areas. So as staff pointed out, this project went through the Historic Resources Board, and the city retained Page and Turnbull, who prepared the initial report. And I have the first and last pages, or the next two pages. And if you turn to the second page I have here, it talks about Page and Turnbull's recommendation to consider a rear 1.5-story addition rather than a second-story addition. And I've been graciously given access to pretty much everything that was submitted to the city by the applicant, and there was absolutely no attempt to do that. Instead, the applicant continued to go forward wanting to build a second story on this lot where second stories are not permitted. So I'm going to talk about the two issues. The first is the tree protection zone. So if you turn to the next page, this is, I believe, also part of the staff report. You can see that the tree protection zone of 35 feet is already been violated in numerous times, including once by the applicants themselves when they not only dug trenches but cut roots. And as I'm about to show you, there is some significant disagreement among various arborists as to what the appropriate tree protection zone should be here to actually protect the tree. And what concerned me was that there was no request by the city and no attempt by the applicant to actually do a little bit of digging and see where the roots are. Could you extend this property out a little bit more than 35 feet and not harm the tree? We really don't know that. All that was ultimately applied was a formula. So turning to the next page, it's the Keelty Arborist's letter of May 27th. And on the second page of that letter, in the highlighted red box, Keelty believes 25 feet is sufficient to protect the tree. And then on the third page of that letter, Keelty goes on to talk about the potential for root cutting, the potential for trenching and excavation, a number of alternatives that could have been but weren't studied that would have made a variance unnecessary. So for reasons that I'm not privy to, a second arborist report was done. If you just turn 2 pages in, it's the August 14, 2018 letter from Dave Doctor. And back on August 14th of 2018, Mr. Doctor concludes that the tree protection zone ought to be 42 feet. But again, it's not very clear whether any studies were done, any excavation was done, any investigation was done into where the actual roots of this tree are located. And then for some reason, just a little under a year later, there's yet another letter. It's the June 23rd letter, also from Mr. Doctor, and he now, for reasons that aren't really clearly explained in the letter, goes from 42 feet to 35 feet. So exactly what's needed here isn't really supported by any, as I could see it, valid arborist report. They're all disagreeing with one another, and no one's bothered to go out into the yard and actually find out. When the applicant needed to do some trenching, at that point it was okay to cut roots of the tree, but apparently in this instance, it's not even appropriate to investigate. And I would ask this commission to at the very least send them back to do further investigation, because it might make it possible that the tree protection zone could be shortened and the house expanded just on the first floor as the law provides, and there would be no need for a variance. I also heard that a number of you went out there, and I hope that you took a walk along the 400 block of Channing, because you'll see that there are at least a half a dozen trees that I saw today that are clearly protected trees, redwoods and oaks, and clearly within what should be calculated as the tree protection zone. In fact, right across the street at 400 Channing, there's 2 new houses, and there's the next document I have here is the plan for that. And as you can see from the plan for 400 Channing and these 2 new homes, these protected trees vertically challenged, and I'm not sure that I could lay myself down between the trunk of the tree and the house. And right after that, you'll see in my package is a photograph of just how close that tree is. And really, if you go out there, it looks even closer. So this is a pretty recent project. These houses are just now being put up for sale. So from a community basis, and you represent the community here, why the 35-foot tree protection zone that then gives them a basis for a variance on one side of the street, and yet allow construction of 2 homes on what had formerly been a lot with 1 home on it within 5 to 10 feet of protected trees. My client's own property, 441, there's an oak in the front. That oak, if you went 10 times the diameter, is too close to the house. There's, I think it's 465 or 456. I think it's got to be 456 because it's across the street. There's a house there also. There's, I think, both a redwood and an oak, and both of those are well within what would be the calculated amount. So it seems to me that as to the tree protection zone, further study should have been done, or there should have been some consideration of allowing for a variance from just the technical calculation, so you can have up to the 1,900 and so square feet on that first floor, and no variance is required. So staff showed us kind of the generic a code for variances, and the next page I have here is just some comments I have on that as to how they apply in this case. So it's what's shown as attachment C. It's also part of your package, is page 22. And among the things that you're not supposed to consider in connection with granting a variance are the personal circumstances of the property owner. And if you turn to the very next page, you'll see a statement from the property owner when they first got started trying to get this variance, basically saying they needed it because they had a growing family. I understand that. I started out the first time shortly after I got married at a condo in Daly City, and we had a child and moved to a house in San Mateo, and our family continued to grow, and we moved to a bigger house in Foster City, so I understand that. But this house has been on a substandard lot since long before the current owners have it. It's had those restrictions on it to not build a second story for quite some time. And so there are alternatives if your personal circumstances require that you have a larger home, but among those is not granting a variance under the Palo Alto Municipal Code. The other thing is B, changes in the size or shape of the subject property made by the property owner. So, I mean, technically, it's not a change in the size or shape of the property, but the decision, as shown in the tree protection plan diagram, to have trenched and cut roots it is something that they chose to do, which ultimately impacts where we are today. So if they didn't do that, perhaps the tree protection zone wouldn't need to be as large as it is, could be investigated further, but again, they chose to take action, and there appears to be no consequences to that. Again, the granting of the application shall not affect substantial requirements with the regulations or constitute a grant of special privileges. Like I said, and I think if you look at the next to last page, it was attachment B, but it's the next to last page of what I have. You'll see that if this was a single story, it would be limited to 1,957.2 square feet, but the proposed development is going to be 2,201.4 square feet. So as a result of a variance, they get to overburden that lot by an additional 57% beyond what they could build if they just were required to follow the law. So if they're required to follow the law, they could build about 420 or 440 square feet, but they get to build 600 and some square feet on that very same lot. I see I got a little yellow light. So I'm going to make the following points quickly. This is sort of showing the lot layout. Again, the lot layout doesn't constrict development. If it was a square lot, it would have actually fewer square feet, and therefore you could put a smaller home on it. Nothing about the slightly odd shape of this lot is actually a constraint. It's actually an advantage because it gives you additional square footage. Which gets me again to my point shown in the map. Building Eye is one of your systems. I don't know if I assume you're familiar with it, but basically you can go on there and look at all the things the planning staff has done. Since 2014, am I done?
Yes, your 15 minutes have passed.
Okay.
You'll have more time during rebuttal if anything comes up.
Thank you.
Okay, thank you. All right, and we are ready for applicant. Thank you. All right, please begin.
Okay, thank you, Chair Templeton. I'm Martin Bernstein, architect for Steve and Ison. I'm also a member of the Palo Alto Historic Resources Board. And I just want for members of the public to know that I've gotten authorization from the California Fair Political Practice Commission that as the architect and without any employees, that the state of California allows me to present this project in front of the commission. The purpose for that is twofold. One, the State of California Fair Political Practice Commission doesn't expect the homeowner to know the technical aspects of building, construction, or processes, nor does the State of California expect homeowners to be able to respond to questions regarding technical aspects from the commission. So that's why I have authorization to present this to you. Thank you. Just two simple statements. One, during the course of the project, we received excellent counsel from the historic preservation consultant for the city of Palo Alto, Page and Turnbull, and we've incorporated all of their recommendations into their report, into our project. And then also we've received good counsel from the city of Palo Alto's individual review consultant, Marmarella, and we've incorporated all his comments into that project. So just my three simple statements are, with all these recommendations that have been incorporated into the project, historic review has been approved by the planning department. The individual review process has been approved by the planning department, and the variance has been approved by the planning department. So now I'd like to introduce Mr. Reyna, the property owner, to continue. Thank you.
Chair Templeton, Commissioners, good evening. Chairperson Ropavar, could you give me the proverbial 2-minute warning?
Yes.
Okay, thank you. Good evening. My name is Steve Reyna. My wife, Aysen Kutlo, and I are the owners of 840 Kipling. We're here this evening to present our project to you, which includes a variance application for a modest second-story addition to our house. Our application has already received, as Mr. Bernstein had said, tentative approval for variance, individual review, and historic review from the Director of Planning. From the beginning, our goal has been a modest addition to our historic house, which is compatible with the neighborhood and maintains and expands on its historic character. Per R2 zoning, we have 673 square feet of unused FAR. And due to the unique circumstances of our irregular lot and restrictions on how we can place the square footage, we needed to apply for a second-story variance. Right. So some of the unique properties of the lot itself, it is irregular. As you can see, we're not a rectangle, we're like a box on a box. This lot and location of the associated driveway has existed since before 1924, and it's documented in a 1924 Sanborn map. Since the house was built in 1912, the lot is probably 108 years old, as you see it. The irregular lot shape and the driveway access along the left side significantly constrains how we can utilize our buildable area. Any additions towards the rear are confined to fit within a very narrow width exactly behind the house. And the lot does, however, have adequate daylight plane to support our second-story addition. Here's a quick picture of the driveway with the easement itself shown on the right-hand side, and the 1.5 foot of extra land for the exclusive and exclusive use variance in perpetuity. Oh, sorry. There's also, wait a minute, pardon me. Another unique condition of our property is that it is effectively a conforming lot. The lot we fully own, which is shown in light blue up there, is 4893. So we are only 87 square feet less than a conforming lot. And with that exclusive use easement there, which is 1.5 feet by 75, that's another 112 square feet. Our total usable land is 5,005 square feet. We are effectively a conforming lot, and as such, we would not have needed a variance for this project. We have an administrative problem with that, but in terms of usable land, we effectively have 5,005 square feet. I would add that the easement itself acts as a zoning function. It acts as additional side setback next to the house where it's needed most to provide additional open space between us and the adjacent property. Now we go to the picture of the driveway, and you can see the easement there. And to the person on the street, it is indistinguishable from the property that we own. So anybody standing on the street, this would look exactly like a conforming lot. We talk again, we're back to the tree protection zone. You know about the trees, the 2 protected redwoods in the back right there, shown with the green circles, with a 35-foot TPZ. So this TPZ is significantly impacted by the structures and the features around there. The dark black are the garage and the cottage next to us and whatnot. And when you total up the total intrusion impact on the TPZ, it's 73% impacted, when planning and forestry allows up to a 25% intrusion. In addition to the structures and the driveway around it, the previous owner of the property behind us, in this area up there, we found out that they had trenched along that fence line for their own irrigation and had installed root blocks. And that's the left-right dashed line there. And the remaining 27% undisturbed TPZ is shown in green. The area is essentially only what's between the trees and the back of our house, and in forward back direction, and the driveway, and essentially our property line on the right-hand side. Back in 2013, we became concerned about potential damage between our trees and the neighbor's cottage at 836 Kipling on the right-hand side because of how close they were. We consulted with arborist Kevin Raftery, who advised us to dig a trench and look at what roots are there. And we discovered significant roots going directly underneath the cottage. Under advisement from Kevin Raftery, we cut those roots. We cut those roots to prevent damage to the cottage and to preserve our redwood trees. If we had not done that, we would eventually have been forced to remove those trees because of the hazard they would cause to the cottage. We did not want to damage our neighbor's cottage. We did not want to lose our redwood tree, which is a very real possibility because it happened to our neighbors. Our neighbors at 836 Kipling, the one story next to us, used to have a very large and healthy redwood tree whose diameter was substantially bigger than ours. There's a picture on the left as it used to exist. And then you can see the picture of where it is referenced to the back of the house. They loved this tree. We loved it too. But because of ongoing issues with the tree and the house, they felt it necessary to call in an arborist to say, what's going on with this? And the arborist told them, this house is destroying your foundation. This tree is destroying your foundation. This tree is just pushing in on your house. Reluctantly, to preserve the house, they removed the tree. And that's what happened. We all lost a beautiful large redwood tree. We don't want this to happen to our trees. We don't want this to happen to our house. Turning now to how the project would present itself to the neighborhood, we have an excerpt of the streetscape from the plan set. As you can see, the proposed second-story addition is centered on the house and significantly embedded into the roof. In fact, more than 50% of the second story is embedded in the existing roof structure. So this can reasonably be called a 1.5-story house or addition. It's a modest addition, fits well within the neighborhood, it's compatible in size, and even smaller than some of the nearby R2 homes off to the right. And is much smaller in height and massing than the DHS home on the far left, 441 Channing. One point I like to highlight here is that the primary concern that the City Council has with second-story additions on substandard lots is the violation of daylight planes and setbacks. Our lot, almost a conforming lot, by 87 square feet, we're missing it, has sufficient daylight plane to support our addition. And the second-story addition fits entirely within the R2 daylight plane, including the eaves. Here's a brief chart that shows the comparison of living space between the different lots along the streetscape. Living space in this case is all the built space above ground, not including garages. So as you can see, first of all, including our proposal, almost all the houses on that street are two-story already, and that the R2 houses range from 38 to 40% FAR. The DHS house on the far left, 441 Channing, 0.58 FAR. Now, the submission from the appellant is actually fairly vague about what they why they are opposing our application. On the first page, second paragraph of their written submission from the beginning, they write, whereas a second story requires a variance and would be injurious to the value and enjoyment of the Gubens-Hahn home. Now, the submission doesn't explain this statement, but the owners have been very focused and very consistent over the last 4 years about what they are concerned about. Up there are quotes. One is an email directly to us. The other 3 are in your packet. These are emails to the city. The most recent one was on December 2nd of 2019. That was only 3 months ago. I won't read all of this, but I've added emphasis to the key points. It's views from their second-story windows across our property. And the most clear expression is the third bullet down, July 2018, which starts out, I realized that the second floor addition, that with the second floor addition, we would not be able to see sunsets anymore. And jumping down to the last sentence, with some very nice views over 840 Kipling, those would disappear. They've been consistently reiterating this primary concern over the years. However, I'd like to bring some more historic context into the views of the owners that the owners of 441 Channing are concerned about. Above is a depiction of the condition of the property as they bought it in 2007. There were a row of Canary Island pine trees, 40-foot plus height, along the common property line. These trees existed prior to the construction of their home and were designated protected trees by the then Director of Planning, Ed Goff, back in 2001 as a part of the SOFA 1 process. In 2009, Mr. Gubens approached us asking if he could remove those and replace them with new screening trees because they were a maintenance issue for him.
2 minutes.
Thank you. Had the original, they became a maintenance issue for us too. These trees were removed in 2009 when the owners, 441 Channing, were first able to enjoy the views across our property. Here's a Google Street View. On the top, you can see the trees as it existed in 2008. Very substantial. We are very heavily shaded there. On the bottom left, 2 years after the trees, there's nothing there. And in May of last year, you can see that the screening trees are still not there. So what is the appellant asking for? The owners of 441 Channing are asking the city to deny our second-story variance request in order to protect their views across our property, a view they created when they removed the tall Canary Island pine screening trees between our properties. The remedy being requested is for the city to violate its own tree protection code to force the addition onto the ground floor, jeopardizing the trees as well as the future structural integrity of the house. I'd like to emphasize that even without the screening trees, there is no significant impact of our second-story addition to their house. We fully fit within the daylight plane, and their second story is 48 feet away from our second story. And if owners of 441 Channing are suffering an injurious loss of light from our second-story addition, then anyone building a second-story addition would be causing injurious loss to their neighbors, even when adhering to the daylight plane. I'll skip that. I'll skip that. This is a picture that shows the neighbor support, 3 adjacent neighbors, including 2 of them here. Thank you.
Thank you very much. Just a reminder, you'll have an opportunity to respond as well after the public comment. All right, so public comment cards, I have some that were submitted early on. Have any additional cards been handed in, Ms. French?
No more cards.
No more cards? Okay. We're going to start with Charlie Brunitsky.
So that's me.
Oh, hey, you don't need to submit a card. Okay. And then William Kane, followed by Kevin Morris and Stephen Shannon. And we only have 3, so you can have 3 minutes each. Thank you.
Okay, my name is William Kane. I live at 832 Kipling. I've lived there since 1995. The house was built in 1895 or so. And when Steve Reyna first approached me, he's kept me apprised of this project from the beginning. I was really pleased to discover that he was planning just to enlarge and make an addition to his house and not to sell it because of his needs. And because if it were sold, what I see driving around town is houses like his getting torn down, being replaced by things that would not be nearly as consistent with the architecture in our neighborhood. And so I think this project is very deserving. It will add, I think, to the neighborhood. It'll probably improve my property value, and I think it's very modest. So I hope you will approve it. Thank you.
Thank you very much for your comments, Mr. Kane. Kevin Morris?
Hi, good evening. My name is Kevin Morris. I live at 836 Kipling Street. We bought our house in 2011, and I just want to say we're very supportive of this project. We're obviously the neighbors on the other side. Stephen Eisen invited us over almost more than a year ago now, to kind of be considerately showed in the plans for the project. We're fully in support of that project. That large we're the owners that actually had the large redwood tree in the back of our house that we had to take down. Again, there were some tears in our house because when that tree was kind of the flagship of our backyard. If you didn't see, it's the picture of the foundation, where our foundation was kind of bent by that tree. That tree was planted before we purchased the house, and it was one of the reasons why we purchased the house in 2011, because it was just gorgeous. So obviously, trees are an issue in this hearing, and actually, we were the ones that kind of lost the tree, and I just wanted to kind of let the commission know that we're fully in support of the project. So thank you very much.
Thank you very much for your comments, Mr. Morris. Stephen Shannon?
So I'm 857 Waverly, so on one of the 2 greenhouses on the Waverly side. Just wanted to say that I'm speaking in support of the project as well. My wife and I both understood what was going on a couple years ago when Stephen came by and explained that they were trying to do this. And our take basically is that the whole community benefits by people who are investing in improving their house and the housing stock in the area. It keeps things well maintained, in good condition. It adds value to the neighborhood. It contributes taxes that pay for schools and services we all benefit from. So, we look at it as the community wins when people invest in improving their housing. So anyway, and every change has impacts. So, right now our backyard faces the subject property's backyard, and our master bedroom is on the back side of our house. So we have a whole bunch of windows. Right now, if you look out those windows, you don't see anybody else because there's walls and garages and trees. The only thing that you'd really see would be the place where the second story addition's gonna go. And, our take is it's nice that we had this privacy windfall for all these years since we moved in 2008, but it's not like God granted us, the right to have nobody able to see through our window ever. So we have curtains. If, we're gonna run butt naked after getting out of the shower, we'll pull our curtains closed. But,
Let's keep it appropriate, Mr. Shannon.
Exactly. But it's, you got to look at it as, I look at it as if I were on the other side, now we're trying to change, build an addition to my house or renovate it. How would I feel about somebody blocking me because they don't want to lose this privacy windfall that they never had any right to in the first place. They just benefited from. And so I think, you got to adapt and be reasonable. And so anyway, so my take is should approve the project and we'll close our curtains and I think everybody will be better off.
Thank you very much for your comments, Mr. Channon. At this time, we will close public comment and begin the rebuttal period. So hearing requester will have 3 minutes, followed by the applicant. Thank you.
Thank you. The gentleman who just spoke is right. God didn't grant anybody rights. The city of Palo Alto has a municipal code, and that granted the rights. The rights is a substandard lot. This is a substandard lot. It's not near a standard lot. It's a substandard lot. I'm not near 6 feet. It's a substandard lot. There's really no argument about that. We're sorry about the loss of someone else's tree. Is this tree going to be lost if they expand further? We don't know that. We had 3 different opinions from 3 different arborists. This isn't simply just granting someone an addition. This is granting them a variance, meaning that we're not going to require you to follow the law in this case. We're going to say that there's something unique about this. And what did the staff say? 2 things, the tree protection zone and the odd shape of the lot. I showed you the odd shape of the lot really isn't a constraint. And the tree protection zone, we prepared a little chart, and if someone could, if I could come up there.
Ms. French?
Here's some extras. You could build the full, as you'll see in this, and we're not architects or engineers, it's just sort of try to eyeball this. You'll see in this chart that you could go to the full 1,900 and some odd square feet on the first floor and still be more than 30 feet away from this tree. And no variance would be necessary. And if there is a variance necessary because of the tree protection zone calculation, then it should be granted for that purpose. Because again, just like everybody bought their home and enjoyed their views, so did Sander and Karen. And they bought their home because the place in part because the place next door was on a substandard lot, and no second story could ever be added to it. And they've enjoyed those views. And really, if you look at the reasons for variance, the very last one is impact. That's an impact. Again, this property could be expanded. It doesn't necessarily have to be expanded to the full 1,900 and some odd feet. If they're concerned about staying out of the 35-foot zone, they could expand to about 1,900 feet, and you could still fit a significant expansion in that property. No variance ever needs to be granted, and the law should be applied. Again, what we're asking you to do is apply the law and not grant a variance, because the exceptional circumstances required for a variance simply don't exist in this instance. Thank you all very much.
Thank you very much for your comments. Applicant?
Good evening, thank you. So I guess it's a collection of things to comment on. He talked about 25 feet, 35 feet, 42 feet from the arborists. The 25-foot was a typo, and we could not get a hold of that arborist to correct it. The 42 feet was the recommendation, additional space because of the redwood trees, and he's trying to deal with the arborist is recommending additional space to deal with the redwood trees' aggressive root growth tendencies. However, in a meeting on September 12th, 2018, the arborist with the city came to an agreement that 35 feet is acceptable and the house and the trees would be fine. Hence, 35 feet showed up in his final report. So I'd also like to point out, or at least point out here, that granting of the variance is to grant relief from strict application of the law. This is not breaking the law. Zoning is a general process where you try to capture as much as you can, but the recognition is that there are cases where the general zoning doesn't necessarily apply, and therefore the variance is created as a process to deal with those cases one by one. So to apply for a variance is not breaking the law. To be granted a variance is not breaking the law. It's following the law if we meet the findings. And staff and the Director of Planning agree that we meet the findings. And the question before you is, do you agree with that? And I have to say that the city's tree protection regulations, they align well with our wish to preserve our trees, because they matter to us at least. And one thing that is kind of clear is that as the appellant raises issues about not seeing this done, not seeing that done, all I can say is that they have not been a part of the process. They don't see what we've gone through. We've reviewed and re-reviewed and considered all sorts of options, including the ones that they have suggested. But considering that with a narrow bit of land that we have between the driveway and the property and the setback and between the TPZ and the house that we have, as we extend back, we cannot recreate multiple bedrooms back there because of the narrowness. You can't have a room and a hallway and a kitchen across a very narrow stretch of land there, which is a consequence of the irregular lot and the driveway access. We have limitations. We have a lot of limitations, and they are strong limitations that have crossed the threshold for a variance. Thank you very much.
Thank you very much for your comments. Before we turn it over to the commission, I want to ask advice. Would it be all right if we ask the hearing requester and the applicant to stay in case we have questions directly for them, or should we only ask staff?
I believe that you can ask the hearing requester or applicant's questions.
Okay, so if you wish to stay in case any of the commissioners have questions, you're welcome to. All right, so the first light I see is Commissioner Olczyk.
Okay, good evening. I just want to thank all of you who spoke tonight for making the effort to participate in our local process. This sort of shared perspectives is the essence of why our meetings take place. So thank you for coming if this is your first time. I want to sort of start this discussion at the end by talking about the findings. And what I'm going to do is I'm going to talk about findings 2 and findings 3 first, presuming that those are sort of less complex, and maybe if that's the case, then we can sort of avoid having to sort of rehash each of the 4 findings as we go through. So I'm going to start with the second finding that needs to be made. The granting of the application shall not affect substantial compliance with the regulations or constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity and in the same zoning district as the subject property. I think that this finding can be made based on the information we received tonight from the staff report and from the several letters that we've got. I think the remarkable component here is that the second floor complies with R2 zoning regulations, and in particular is well within the envelope of our daylight plane, which is the right, which is the threshold that we use to evaluate the inconsistency and compliance. So I think that finding can be made. I also think that the secondary variance element, the issue with the wall, also considering that if this was just an HIE discussion, it would be compliant. I think that suggests, plainly that this finding can once again be made, because this wouldn't violate again the substantial compliance with our regulations if this had sort of fallen within the HIE exemption, the improvement exemption. Okay, I'm going to move to finding 3, that the application is consistent with the Palo Alto Comprehensive Plan and the purposes of the title. And I think in this case, staff did a good job of outlining that in their sort of determination. I'm happy to go through this if we need to, but unless somebody feels strongly that our comprehensive plan policies somehow are violated, I think that the staff report speaks strongly to the case that the comprehensive plan as a whole, and in particular the policies that were enumerated in our staff report, satisfy finding number 3. But I'm happy to.
Pardon me, Commissioner Olczak, I want to just clarify, so.
I know this is not from staff.
Oh, I want to, who provided this document? Okay, the applicant. Thank you. I just wanted to clarify that. Thank you.
No, I mean, I'm referring to packet page 18 for the findings that we need. And then I thought in particular, if we are, hold on a minute.
Thank you for helping us follow along with your thoughts, Commissioner Olczak.
Yeah.
47 as well.
Yeah, and then I was going to say, packet pages 46 through 49, or excuse me, 49 are the crux of the director's report. And I think that unless there's, I'm happy to double back on it, but I'm going to suggest that the statements made on packet page 48 regarding finding number 3 are really sufficiently make the case that that finding can be made, and I would agree with that analysis. Okay, I'm going to go to finding 4, which I think is a little more complicated, and in particular, the question about whether the application would be detrimental or injurious to property or improvements in the vicinity, and then how it reflects on public health and public safety and general welfare and general convenience. I think one of our speakers tonight was, spoke quite humorously and eloquently about the notions of privacy, and we've grappled with these ideas of single-story overlays in the past, and one of the things that I use when I consider these notions of second stories, single-story overlays, our code creates a set of sort of strict regulations regarding daylight planes and second-story additions, for example, within R2 zones like this one. And I think that if a variance, requested some, flexibility with respect to encroaching over a daylight plane, this would be a very different story. And I think when I think about the notion that we're going to evaluate whether something can be detrimental or injurious to a property or an improvement in the vicinity, I think about value. And from my perspective, the bar of determining whether you can be injured by sort of the execution of, let's say, an improvement on your property is whether it would conflict with the standards that we set within a zoning, within a zone that applies to sort of all projects within that zone. So regardless of whether a lot is substandard in the R2 zone, I would suggest that we consider injury to be present when a project would exceed regulations general to the zone, as opposed to specific to the lot. And the reason why is because if you don't, then the entire concept of a variance is impossible. If adhering to your zone's regulations would injure your neighbor, then you couldn't evaluate a property for its special circumstances to determine whether it should theoretically be allowed to do something that it would otherwise be allowed to do except for X, Y, and Z. That wouldn't be possible. And so I think this would be an entirely different scenario. For example, what was being asked and supported by the planning staff was something that would actually cross the line of what is permitted in an R2. So considering that the application is within the envelope, for example, and because we talked a lot about privacy and views, within the envelope of the daylight plane, I think that should reflect how we evaluate whether such an improvement could injure a neighboring property. And so that's how I'm approaching the finding in number 4, that the expectation should not be that the neighboring property is entitled to anything more than what is strictly provided for by the zone. And if the zone allows for this daylight plane, then anything up to that daylight plane, in theory, can't, by definition, injure the property. Okay, I'm going to move on. I'm not sure it bears mentioning, but I think that alternative build-out suggestions here, if they did in fact negatively impact trees, I think we could be in a very similar situation where a lawful application to develop on this site, if somehow could be approved by the city in contradiction to the sort of city's arborist's findings, could theoretically be appealed, because if it did pose a risk to a tree, that could very much be, qualitatively injurious to the community. So it's sort of interesting, not that the part of the evaluation from a variance perspective, but I just wanted to add that. Okay, I'm going to move now to finding 1, and I appreciate you guys letting me have this extra extended time. The critical finding number 1, which sort of goes to the heart of all variances, because of special circumstances applicable to the subject property, including but not limited to size, shape, topography, location, or surroundings, the strict application of the requirements or regulations prescribed in this title substantially deprive such property owner of privileges enjoyed by other property in the vicinity and in the same zoning district as the subject property. We're not to consider the personal circumstances of the owner and any changes in the size or shape of the subject property made by the owner or his predecessors in interest. So I'll just acknowledge one thing. I was not made aware of personal circumstances of the owner except for in the letters I received from the applicant of this matter. So I'm not sure if that was a component. I imagine it wasn't of the staff's review, considering their familiarity with the code. I think that, well, let me say this. First, I appreciate the invitation by the project applicant to sort of get out there. I think so much of our review sort of requires us to assess factors like size, shape, topography, and the opportunity to get out into the community and see these things is profoundly helpful. And so for those of you that were able to do that, I think it probably improved your analysis. Okay, so one of the components of the finding that I think, one of the components of why I think this first finding can be made is, number 1, the irregularly shaped lot. I think that the shape of the lot has forced us to approach any improvements on the site in a unique way. And then, but for the TPZ zone, we would be able to do something very different here. So it's not necessarily that the irregularly shaped lot causes all the problems, but the irregularly shaped lot in conjunction with the TPZ zone set by the arborists creates an almost impossible situation where the homeowner, despite being able to improve the lot based on its current size, can't effectively do so. And I think there was an interesting discussion about the easement. I'm not really clear why this easement that stretches almost the length of the property was recorded as easement as opposed to a lot line adjustment. It seems, I don't know that it falls within the special circumstances precisely, but the notion that there is effectively a non-legally defined property line that encompasses enough land to make this potentially not substandard. I don't know if that would still be the case because of the width, but potentially not substandard lot, I think is interesting. I don't know that it is a component of I don't know that it is a valid special circumstances, because if, for example, the property owner acquired the land that forms that easement, that would be a change in the size of the lot, which is something we are not supposed to consider. Although I will say that we have experienced in our review on this commission situations like this that go back before time. That's what, anything that happened 112 years ago is essentially prehistoric. And one of the things that I think is problematic here is that looking at the shape of the lot, you have to wonder, why was it set up like this? So I don't know that that falls into the category of special circumstances, but it is a component that I would suggest should be considered by the council when they review it. So one of the arguments that the appellant or applicant, I'm not really sure what the title is. Is it applicant tonight? The appellant is the applicant?
The applicant is the applicant, and the person who's bringing this before us is the hearing requester.
Okay, I'll continue. So all previous references to appellant is hearing requester. And from now on, I'll use that word. So I'll suggest some of the comments made by the hearing requester that regarding the arborist report. It's been my experience that Dave Doctor may be the most highly regarded arborist in this city. Am I surprised that his initial finding was 42 feet and then, staff and whoever pushed and he went down to 35? Not surprising. I feel like arborists are consistently sort of pushed into corners and asked to be more conservative. My impression is that he's spent more than enough time evaluating the TPZ, which is a significant component of the special circumstances that I think make finding one possible. And I think it would be a waste of time to reassess or reinvestigate and a waste of resources. I think we should be able to rely on those two reports just based on his tenure. And then I would add that I think when you review the staff report, I'm drawing your attention to packet page 47. Staff sort of addresses all these special circumstances, that there's a historic relevance here that makes this property unique. So reshaping its, or demolishing it or rebuilding would be an undesirable result to achieve the solution within the framework that's allowed. Yeah, and I'll end on this because I feel like I'm taking too much time. I'll end on this. This is not the first variance that I've reviewed as a commissioner in 8 years, but it is, to the best of my recollection, the first time staff has recommended approval of one. And I mention that because it is true, variances are supposed, staff has set an exceedingly high bar for variances, and but if we never grant one, in particular one with this much sort of supportive evidence, then it's essentially not a tool that our city uses. So I take the recommendation by staff to be quite influential on my sort of conclusion. But that's it for me tonight. Thank you.
Thank you very much. Commissioner Riggs, followed by Commissioner Suma.
Well, I'll be simple. I have 4 points. I evaluated the application in the packet, and I don't really have questions. Point number 2, I can make the findings, and I think that to reiterate the points that were just made, I find this a very good case for the application of a variance. Particularly, I think some of the special considerations that Commissioner Olczyk mentioned, the tension with the tree protection zone, as well as the, I find the easement really provocative. And I'm ready to move to support this staff recommendation when everybody else is ready.
Thank you very much, Commissioner Riggs. Commissioner Suma?
Thank you very much, and thank you to the staff and all the presenters. There was a lot of really great information here, and I have to say that I agree with the comments of Commissioner Olczyk. I think the fact that this variance, we have a variance so it can be used, basically, and used in the right way. And this project has checked all the boxes in IR, daylight plane. It is effectively in terms of lot size, compliant. I mean, it's odd to have an easement that only one property owner has a right to, so it's effectively part of their lot, since there is no other party that has any access or rights to that easement. I am also struck by the thorough review of this project, and in addition to making the findings, which I won't go into detail because I think Commissioner Alcheck did a great job, I also think that this property and this applicant adds value to the neighborhood. They are preserving a historic resource and a precious tree resource for the whole community. And I'm not sure it's appropriate really for someone else to suggest how they might build on their property, but I think that it does look like kind of a half story from the front, more like a dormer than a full story, and I think it's appropriate with a architecture. And I think also that substandard lots in really old parts of Palo Alto, there's all kinds of crazy lot lines and situations that people, that you want to resolve in the best way for a homeowner that wants to bring all this value to the community. And I'm also struck by the support from nearly all of the neighbors and the fact that they feel this will improve their property values. So I'm also ready to move the staff recommendation.
Thank you, Commissioner Suma. Commissioner Lowing?
Yes, first, I'd just like to acknowledge that this is a very complicated issue relative to staff presentation, and I thought it was just an unusually thorough report that came to us to really lay this thing out. And if you don't come to every meeting, you don't realize that I don't say that at every meeting. Nice job. So it's particularly well done, really well done. I wanted to ask a couple questions before getting back to the substance from the applicants of the city, from the applicant's letter. And so no, not the applicant, the appeal person. On page 62. Right. We'll work this out later. Page 62, which is the letter from Mr. Brunitsky. And the last three paragraphs on that are basically all talking about the tree protection zone, and that's been addressed by the homeowner as well. So I take it, I'm just confirming this, I take it that the city is very comfortable saying that, that 35 feet is the thing that we're supposed to be looking at right now.
It's a great question, Commissioner Lawing. We are comfortable with that 35-foot tree protection zone. We do have a member of the urban forestry staff here. If you do have further questions, she could go into detail about the calculation method used for that zone if that was desired by the commission.
No, I just wanted to confirm that that's the city's firm position. And that's on the next page, 63, there was also reference to a number of other properties that seem to be closer than 25. And assuming that that's true, can we just get some guidance on, how that could occur, or what's there? Or, I know they're not part of the variance, but I understand the appealer's question there.
Yeah. I don't think we need the slides, Chrissy, but in case we do, you'll have might as well bring it back over here. Ms. Fong did look into other properties that we were made aware of by the hearing requester, and we did look at the redwoods that were similar there and of similar size and stature, and found that I think the tree protection zone was consistent. There are certainly other types of trees on some of those properties, oaks namely, that are also protected, but of a different size and stature and different root system than the redwood trees. And so we did compare the redwood tree protection zones on those neighboring properties. Do you want to speak to that any further, Ms. Wong?
So I just want to speak on that from my planner perspective when looking at those trees. So we evaluate past permits and also the existing situation there. It appeared that those tree protection zone is consistent with the previous building footprint. So basically, what is new right now on the site is pretty similar to previous situations on site when the development is built close to the tree itself. So we are not supporting anything that we are currently seeing on site in the existing situations. We are just basically approving what is existing there.
Approving what? I didn't hear that.
What is existing on site right now. So we are not pushing the new building more toward the tree. We are maintaining what is already there as a existing impact.
Okay. And then I also just wanted to confirm what I think we're saying. And this is on the plan T2, where it just shows that, I don't know if I can get this number that quickly, but it seems like about 75%, because of the neighbors' houses and cottages and so on, of the existing tree zone has already been penetrated. So if I understand that graph correctly, that makes even more severe the fact that these trees are going to be at higher risk if there's any more building within what's left of the free root growing zone for that tree area, correct?
Yes, I believe you're referring to the neighboring properties where the root system of this tree stretch, and there are perhaps some challenges maybe for the root system that currently exists.
That's right.
Yeah, we certainly wouldn't, I think that's part of what we want to look at with this tree is not just what is on this property, but the totality of the root system of the tree. And so we certainly want to make sure that it is protected. Christy, do you want to speak to the impact? Are you asking if there are other proposed plans on the rest of the root system, or just the current condition?
No, I'm asking if the situation is particularly severe because so much of the complete circle has already been penetrated,
Yeah.
and so there's not as much left. It looks like a reasonable portion on this property is left, but in terms of the entire growing area for the trees,
that is correct.
There's not much
Yes,
left.
that is correct, Commissioner Lawing.
So the severity is increased in this particular location. Because there were some comments from the folks that appealed that there's other invasions in there. So why can't we have an invasions? And that's the answer, because there's already too many invasions, and we need some space for that tree to spread its roots. Without going off on a tangent, I think that in some cases homeowners can say, I need to take these trees out in order to continue like the neighbor, but in order to do my building, and I can't get it done. But the choice, if the city or we're trying to opine on that, of removing 2 redwood trees or having a small addition as a second floor, I think is just, there's no sense in spending any time on that, as opposed to having recorded that as a position. And just a comment on the perceived problem here. The perceived problem from the one who is appealing is that it is the views of a house, I guess, instead of nature. But they took the trees down, the large trees. So, there are other large trees that can be put up at, frankly, any size, depending on how much you want to spend per tree. That can be happening, in the next month. So I just would associate my thoughts on this thing with what Commissioner Alchek had already said and what Commissioner Suma added. I do think that the findings could be made, and I'd be supportive.
Thank you very much. Commissioner Heck.
Thank you. I'd like to actually start with a question before I begin my remarks. In the hearing requesters' remarks tonight, as in one of their second letter, the council's second letter, he referred to the Page and Turnbull report. We saw the first page of it here tonight in the supplemental packet, dated March 19th, 2019, discussing the possibility of, I think, a 1.5-story addition at the back of the property. But as we read in the staff report, ultimately, Page and Turnbull found 10 of the 10 factors for the proposed plan that's before us tonight. And so I'm wondering was there a Page and Turnbull letter after the March 19th, 2019 that perhaps that could be explained to me.
Ms. French, who is our historic expert, will answer that question.
Well, at least I'm the Historic Resources Board liaison. I see a lot of these things. So the Secretary of Interior standards, 10 of them, yes. Page and Turnbull submitted a subsequent letter. This was an earlier version, so we have version control issues. You're not seeing the later version that the HRB did have a look at and did get to consider as they were looking at the revised plans that came back in. So they did make the findings that all 10 Secretary of Interior standards for rehabilitation were met with the proposed plans.
Okay, thank you for that clarification. So I'd like to sort of start with the function of the variance generally, and of course it's a state law. Same variance findings apply in every jurisdiction throughout the state. We actually add a couple more to the state law, our findings 3 and 4. But really the function is to look at a site and ask if it is constrained in some unique way from enjoying the same privileges its neighbors do in the same zoning district. And those constraints, it's clear in case law, those constraints are often physical, like a creek running through your property that squeezes you toward a setback, but they can also be legal. Legal constraints on your property are constraints, and those count too. And so that was kind of the framework that I came with when I looked at this application for these variances. And so what I see is today, there's a single-story house on that property. And there is some room at the front of that house between the face of that house where the door is and the front setback where there could be an expansion. But there's a law that says you can't build out that direction. And that's a law of the city, and it has to do with the historic nature of this property and the importance of retaining the historic facade. And so that is a constraint of this site. That's one reason limiting available development moving forward. And then looking backward from the back of the house where the current design does move back to basically to almost the edge of the 35-foot recommended setback from the tree. We have another legal constraint, and that's the TPZ. And so this house is squeezed at front and back, and that raises the question of whether some modification of some law of the city is appropriate to allow this house to enjoy the same benefits of its neighbors in the R2 zone. So I do appreciate the concerns of the neighbors at 441 and your articulation both in your personal emails and the comments and letters of your council. But one place that I felt that I was constrained in considering them, and that is that our decisions, our recommendations need to be based on something called substantial evidence. And those are essentially facts and expert opinions on expert subjects supported by facts. One thing that's clear, and I know this better than most as a land use lawyer who is occasionally reminded of this, lawyers' arguments are not substantial evidence. They can contain facts that are evidence, but they are not themselves substantial evidence. And so while I was interested in the position that the 441 neighbors have on whether or not a further incursion into the TPC is advisable, recognizing, as I know they do, that the recommended incursion is 27%, leaving 73% uninvaded, and in fact it's already squeezed down to only 27% uninvaded. But recognizing that, I don't have in front of me an arborist analysis that says it's okay to further invade that. The one I have says it's not okay. And I do understand that the TPZ is not just an issue of distance of a tree from a structure. I know it's more complicated than that because that's evident in the record. And so to me, that's one of the things that I found constraining in my desire to want to give sort of full credit to that position and look at whether the TPZ could be reduced is I don't have an arborist telling me it could be. Another aspect that of substantial evidence that I think is that I'm guided by is, of course, it needs to be relevant. And I thought that the neighbors at 4401, their counsel made a good point that the personal circumstances of the applicant are not relevant, and I agree with that. And but I note that in the director's findings, which are the findings from which the hearing request springs, those didn't make reference to those personal circumstances, so I don't believe that they're part of the findings. So while I agree with the point, I think that staff and the director appropriately handled those. Other, frankly, irrelevant, in my view, aspect, which I've heard in both directions here, is value. That's not a part of any finding here, and I think experts may, well, we had disagreement in this room as to whether value would be affected, but I can, it's not, to my thinking, part of any of the findings. So as I'm looking at this, what I am seeing is we have a director's decision with a series of findings, and I've reviewed those, and I agree with those findings. There are 3 additional findings that I think support the granting of a variance, and I'd like to, and those are all based on information in the record, and I'd like to provide those because I don't think they are clearly delineated in the director's findings, and so I'd ask, to the extent my fellow commissioners are intending to support the staff recommendation, that they consider whether or not they'd want to include these additional findings of fact with the findings made by the director. So the first one is a finding of fact supporting findings 1 and 2. These are the findings 1 and 2 are the state law findings for a variance. As reflected on sheet A 2.0 of the current plan set, 840 Kipling has a current height of approximately 18 feet, and the adjacent properties at 836, 834, and 832 Kipling, all of which are in the same zoning district as 840, are approximately 18 feet, 23 feet, and 26 feet respectively. So therefore, exceeding the 17-foot height is a privilege enjoyed by other properties in the same R2 zoning district, and I think, again, that is a finding of fact that supports the granting of this variance, the first variance, which is to allow construction to exceed 17 feet. Then the second additional finding of fact, this also addresses the state law findings 1 and 2. This one relates to the other variance, which is at the rear side wall of the property. The 6-foot segment of wall, which is the subject of the second variance, is replacing an existing 6-foot wall segment which currently encroaches in the side yard setback area. The replacement does not lengthen the area of encroachment and modestly reduces the square footage which would otherwise have been added to the second floor. And then the last additional finding of fact, this one supports finding number 3, which relates to the comp plan and the local area plan, the SOFA cap. The plan is proposed for 2 stories. It's consistent with the 0.35 site coverage max, which is applicable to as I understand it, to a 2-story home in the R2, and to the 0.45 FAR max, which again is applicable to the R2 zone. And incidentally, that 0.45 FAR max does not require a variance. So that plan is consistent with the applicable site coverage max and FAR max, but it does require a variance to exceed 17 feet in height. If alternatively, we take the 489 square feet, which and construct those on the first floor at the back of the house, in addition to further invading the TPZ against the recommendation of the arborist, it would require another variance for a 0.45 site coverage, where 0.4 site coverage is allowed for a single-family home. So really here, what we have is not a choice between a variance and no variance, but a choice between two different variances, one to go up and one to go back. And again, that's ignoring the TPZ. In this choice between the two variances, the variance to exceed 17 feet is more consistent with the comprehensive plan and the SOFA cap because both of these plans include policies to protect and preserve heritage trees. And so that's the third, again, supplemental finding of fact that I would suggest be included with the recommendation to the council. Thank you.
Thank you very much, Commissioner Heckman. Commissioner Rupert, you're good? Okay. I just have a few quick comments before we move on to the consideration of the findings. So first of all, I just want to thank Ms. Fong for a very thorough presentation and report. We all found it a lot of the details we were looking for were already there, and it was just an absolute pleasure to read, so thank you. I would also like to thank the hearing requester and the applicant. You both gave very compelling presentations and presented your case very strongly. I will also be agreeing with my fellow commissioners who have spoken about moving forward with this variance request for all the reasons that were given, specifically or especially that the variance is meant to, the variance process is meant to address edge cases like this. I particularly appreciated Commissioner Alczek's point about the variance being specific to lot, but that the proposal conforms with the zone requirements. I also wanted to say that many of the constraints were addressed on an individual basis. Rather, the problem is that we have these multiple constraints, and because, like Commissioner Heckman said, because we have the multiple constraints, you can't address them individually. You have to think of them as in a combination. So I think that strengthens the justification for approval of this variance. Also, I appreciate Commissioner Heckman's comments about legal constraints and site coverage. I thought those were good points that we had not seen through that lens earlier. And then another comment about the push-pull aspect of how we can view this, and that may help the hearing requester come to terms. I would also say that the view could be harmed if the tree were to be damaged or to die as well. Like, there are multiple ways that a view can change. And it's not just the building of a structure. There are a variety of risks that have been evaluated by the team, by the staff, and the applicant. And I think that it is admirable to the extent to which that the applicant has been thoughtful and considerate and engaging in the various processes and getting the input and the feedback from as many applicable sources as possible, including the HRB and the tree protection. So those are the reasons I'm inclined to support the variance request. Thank you. It looks like we have two comments, Commissioner Riggs and then Vice Chair Rubivar.
I was going to make a motion, so Vice
thanks.
Chair Rubivar.
Yeah. I'll be brief. I just had one follow-up question for council, city council. Correct me if I'm wrong, does a property owner have a right to their view? I don't believe they have a legal right to views. I think that, no, not daylight planes, but just plain
Yes.
right to, do they have, you
You're
have a
correct-
right to?
You're correct, Commissioner. Under California law, there's
Under
no general right
to
to a view.
Okay, that's right. There's daylight plane privacy, but no general right to view. That's just the point of clarification I wanted. Thank you.
That's actually stated on page 49 of the report, so. In different words, so.
Thank you, though. It's a good point to bring up for both of you. All right, Commissioner Riggs, you want to make a motion?
Yeah, so I'll make a motion to support the staff recommendation to support the second-story addition and the variance, and but also recommend that staff include the 3 additional findings suggested by my fellow commissioner, the first 2 being tied to findings 1 and 2, and you can correct me, Commissioner Heckman. The first 2 are exceeding the 17-foot height limage. Limage is a privilege supported by other landowners. That the second one would be that the rear side wall replaces an existing encroachment. I'm just paraphrasing. And then the third finding that he added, which supported, I believe, finding 3, was the idea that you have limitations with regard to site coverage and FAR, and basically you're choosing between 2 different variances, and 17-foot variance is more consistent with the neighborhood than adjusting the FAR given the limitations of the site. Hopefully staff can adjust those, but I think that we should include those in the recommendation.
I'll second.
Oh, beat me to it. I was going to recognize Commissioner Vice Chair Rupavar. All right, so seconded by Commissioner Lowing. Any discussion? Commissioner Alchek.
Okay, so I have to ask, because we're going to vote on it. I didn't take notes while you were talking, but is the notion that this is to the number 3, is the notion that it's a choice between 2 variances, is the notion that because of excluding the TPZ for the moment, which I don't think we need to do that, but excluding the TPZ zones, that the theoretical FAR there allowable would exceed the lot coverage requirement, somehow would be relevant to pursuing a variance? And the reason why I ask that is because if you are theoretically allowed to add a certain amount of FAR, but your site coverage would be violated, my impression was that you're not entitled to that FAR. So it wouldn't necessarily be something you could.
Right,
That's the point.
Sorry. Through the chair. So the point was, if they wanted to pursue that same square footage, right now they have a 0.45 FAR, right, which happens to be in 2 levels. If you push the top level down to the bottom, it's still 0.45. It's just all on the ground level, which makes it a 0.45 site coverage and a 0.45 FAR, right? So the 0.45 FAR is allowed, but the site coverage would exceed, and you're correct that the law doesn't allow it, but if you wanted it, you'd be seeking a variance.
Right. No, I guess what I'm suggesting is I would find it unlikely that staff would support the rationale for a variance in that particular situation. You take, for example, a single overlay area. They're not entitled to a second story. They may be entitled by the, it's hard to imagine a scenario where their lot size would entitle them to a FAR that would be larger than their site coverage maximum. It seems like those are intentionally similar, but
Commissioners, I'm going to rein you in here on this one. It's a bit of a hypothetical, and I love the thought exercise.
All right. Well,
but is there any adjustment you'd make?
Well, I think that we can condition it by tweaking the motion a little bit, that we can make them that staff consider these suggestions in the report to council. I don't know that we need to be prescriptive on these because there will be a staff report to council. These were suggestions by Mr. Heckman. If we build them into the motion as suggestions to staff, then they'll be presented as such if appropriate. And so I would assume that spirit will be carried forward in the motion. If I need to be explicit in the motion, I will.
I'll just say this. I did find it very compelling, the notion that the SOFA guidelines specifically made a preference for tree preservation. So I think from that perspective, that is a good finding of fact. And I actually think that adding the finding of facts would be great. So I support the idea of making a hard recommendation. I just, forget it. Forget I said anything. I apologize. It was confusing and complex, and I apologize for asking the question.
All right, I have to check in with our seconder. Do we want to take the change that?
I believe staff.
Oh, did you? Okay,
Just wanted to, if I may, support what Commissioner Riggs is suggesting. I think it would be unlikely for us to, in the findings, and not that this is what Commissioner Heckman was suggesting, to compare it to a hypothetical variance, because that's not what's before us. But what I did take from that and do appreciate is both the comprehensive plan and SOFA, how they would prefer for tree preservation, historic resource preservation, which is in line with the spirit of what you're saying and kind of the thrust of that. So whether you need to amend the motion to be that staff consider the spirit of these things, I will say that's what I was taking from that, and if that is indeed the spirit of the suggestion, I think that is fine and consistent with what staff would be comfortable pursuing.
Commissioner Riggs.
Thanks. I mean, given, I think, what this dialogue we just had, I think the motion is fine. It said, I think the way I phrased it was that they consider Commissioner Heckman's suggestions, and I think I would trust that staff would carry those forward to council. So I would just prefer to leave the motion as is.
Sounds good. Seconder, we're good?
Yeah, no, I thought you were going to try to take them out again, which I think they should.
Okay.
They should stay in there. Okay, we got it. All right. Boom.
Any other discussion? All right, let's vote. If you are in support of the motion on the table by Commissioner Riggs, please raise your hand. All right, any opposed, any abstain? Oh, no, I'm just kidding, it was a 7-0, so. All right, well, thank you very much, and thank you again for your time and coming before us, and especially to the folks outside the application process who came to chime in. I appreciate that so much. All right, so let's move on. Approval of the minutes is the next agenda item.
Go ahead.
Motion to approve.
Second.
Commissioner Heckman.
Sorry, I have three minor changes to the minutes. So let me tell you what they are, and then
Please
perhaps
continue,
the moving party might entertain an amendment. Page 39, lines 3 and 6, the word flushed with a U should be fleshed with an E. Page 69, line 12, the term for at least.
Can you hold just 1 moment so I can make sure that I'm capturing this? I just want to get my document ready.
Oh,
Could you repeat the first one?
I gave this like 3 weeks ago.
Okay, I'm ready. Thank you.
Okay. So page 39, lines 3 and 6, flushed should be fleshed. Page 69, line 12, the language for at least, drop the for, so it just says at least. And page 74, line 5, where it says nominees, period, I want to, there should be a comma there instead of a period. Thank you.
Does the maker accept those amendments?
That sounds good.
All right, seconder?
Yes.
All right. All those in favor? Approve?
Commissioner
Where did you land? He's abstaining. Okay, great. He left early, but that's fine. Okay, thank you very much. And then committee items. Is this the appropriate place to talk about the XCAP? All right. So we had an XCAP meeting earlier today. That is the railroad crossing discussion, and it is we up until when I left to come here, we were working on items to exclude from railroad crossing consideration, and the items that we agreed to exclude so far are both of the tunnel alternatives. I don't know what happened after I left, but I'll keep you informed as I learn more. Any other committee items, North Ventura? Oh, great. Commissioner Riggs.
I just have some, I have some needs with regard to adjustments on the schedule. Page 5. I think I told staff a long while back that I'm in China. Well, I may be in China, depending on what the State Department allows me to be in China the whole month of May. I told Ben I'm not able to attend the rescheduled meeting. 4/8 I blocked out, and I'm traveling on the 15th. I'm also traveling on the 29th of July. And that's as well as I know my schedule right now.
What did he say? Great, thank you. Commissioner Suma.
Oh, I just wanted to remind everybody to come to the NVCAP meeting tomorrow evening. Is it at 6 or 6:30 it starts?
6 o'clock doors will open, there'll be some refreshments, and people can go in, and 6:30 is presentation.
Okay, at Gunn High School, in room, I think 115 and 116.
Yes, in the Community or Student Activity Center.
All right, thank you very much, Commissioner Suma. Commissioner Alchek.
Okay, not a committee item, just quick comment,
Okay,
if we're okay with that.
that's fine.
Okay.
We'll move
okay.
on to the commissioner questions,
So,
comments.
just because we have a relatively new director and also some relatively new commissioner, I want to just sort of acknowledge two things, make sure my understanding of this process is the same, and that way it's sort of said out loud. We have these assignments for commissioner representation of the city council. I think, and this, you may already know this, but past practice has been that when an item that staff believes council would like to have some representation of the commission is on the agenda, they sort of give notice via email to the individuals in order for the given month. And so, for example, in March, for example, the theory would be that I would get an email if I was responsible, if I was required to show up. If barring an email from staff, you wouldn't necessarily have to be at the meeting because items on that item, because your representation of commission hasn't been requested or thought relevant. That, just want to make sure that's still our practice. And then the only other thing I mentioned, just because it came up tonight, typically all the agenda item minutes adjustments can be made via email. And we tried that. Oh, and it didn't work? No. Oh, okay. All right. All right. In the past, typically we haven't reviewed a second set of minutes. So if a commissioner sends in changes to the minutes, they typically get accepted, although typically they opine on their own comments, not on somebody else's potential comments. I don't know if that's still the practice. And then if there's an issue with that, is that because you're not sending out a second revised minutes for us to see, or?
Well, in this case, what we would do is we would consider the minutes accepted with the revisions that have been suggested. Is that?
Yeah, I'm saying, like, is there a process that we don't have to do it on the dais? Because that, in practice, we've had a process where we could just email and say, hey, that's not what I said this, and whatnot, and we don't necessarily have to go through them all at the dais. That's sort of what I'm wondering.
Yes, we should make sure that it continues to be the practice, and if there was a mix-up or anything, we can make sure Vin knows it'll be his first time really kind of doing this as well. So, yeah,
Okay.
we can make sure that
Just wanted
those
to clarify that was
communication lines are all open.
Thank you.
I would add to that and say maybe just a two-sided handshake. So if a commissioner sends in a comment, if he can then respond, I've accepted these edits, then we know that they'll be accepted by the time we approve the minutes.
Great.
Also regarding the council representation, I discussed this with Ms. Tanner, but the Monday discussion did not fall into our historical category of flagging a representative from the commission to attend council because the council was not considering an item that had come before this commission. They were considering an item that was about this commission. However, I would say, since we've been talking about edge cases here tonight, I would say that would be an excellent edge case to think about notifying the commissioners heads up about this. I could have also done that, and I did not do that, although Commissioner Lowing and I did attend and speak up on as commissioners.
I think that's a great idea.
Okay. As far as the future agenda items go, what's going on with that?
Even though there is a blank on March 11th, we do have an agenda item that is coming forward regarding a pause that was placed by council on participation in lieu parking downtown for a new office development. And so we'll be bringing forward for your consideration extending that pause to the next meeting that we have on March 11th.
Okay, and I recognize this a question that is going to be slightly out of your scope, but since we were all there on Monday, we did have a new item from the Transportation Department that will be coming before us. Would you mind sharing a little bit about that?
Right, so on Monday, there was discussion of Ross Road and our Bike Boulevard program, and council approved. Sometimes their motions are a little challenging, so I do want to make sure I get the action minutes. Approved going forward with, particularly I think was the signage for the roundabout, and then the signage discussion was approved by council, but coming to PTC for further consideration. And I do believe that we want to bring that in March. So I will talk with Philip to see if it's possible to bring it on the 11th. Part of it is just the noticing that we need to make sure we do would be this week. And so to make sure that we could notice this week to bring that on the 11th or the 25th. We do have a fuller agenda on the 25th because we will be bringing the NVCAP before you for a study session. And so that will be a pretty robust conversation as well.
That would be wonderful. Just to answer for those that were not present, we got a lot of community feedback about the roundabout that exists at Ross Road at Meadow, and it's had 3 collisions since installation, which exceeded the amount of collisions significantly since before it was installed. And so there's been an urgency brought before the council to address it. And so that's why the signs that were approved by the council were approved in the moment, but they also wanted us to look at the intersection and see if we had additional recommendations and conversation to have with staff. Is that, okay? You're not, okay. So I would say it would be really good to schedule that at a time that Commissioner Riggs is present and that we have, yeah.
I mean, I talked to Philip. I think one thing that I'd like to see is actually appropriate. I mean, this happens when we rush items in, is that we don't get appropriate modal counts. And I think what we need to do is be able to address perceptions in these cases. So if we could just relay to Philip that we do need appropriate counts by mode.
Hold on, we can't discuss it tonight, it's not agendized.
But I mean, I'm not discussing it, I'm saying to review this,
okay.
What we need. So,
okay.
I mean, like, this happened in the past where we get the items and we don't have
the information
I don't have PED, if I don't have PED and bike counts parallel with traffic volumes, I can't make an exposure judgment. And collisions just are they're Bayesian.
Okay.
Okay, yeah, thank you, Commissioner, and thank you, Madam Chair. We do have to keep this matter to a minimum in terms of discussion.
But this is not a Ross Road discussion. This is a pattern we've had from the Transportation Division in getting items that were where we didn't have all the data.
Sure.
So I just want to make sure we have all the data if we're going to get an item.
Okay, Commissioner, and you indicated that you have spoken to the Chief Transportation Official, and you certainly are able to speak to him as well about these concerns.
Your comment is noted, and we can make sure that we come with the appropriate data. There was quite a bit of data and information provided that may not have been highlighted at City Council, but we can ensure that we have that information if it's available.
That would be great. And that also brings me to another point. It wasn't agendized tonight, so we can't discuss it, but I would like the commissioners to all consider proposals for ad hoc opportunities to engage. This might be a great opportunity for Commissioner Riggs to
I won't be on an ad hoc committee. It's not something I want to participate in.
Okay. However, you want to provide the feedback to the Transportation Department, please feel free to do so. That we will also be agendizing consideration of ad hoc committees that may be like smaller with particular expertise and allowing people to feel a little bit more engaged on particular topics with staff. If that interests you, please let me know, and we'll be working that out to get it on the agenda in the near future.
Madam Chair, if I may, one item I've neglected during the director's report is for the schedule. Vin did, I think, poll most of you to find if we'd have quorum for the 15th of April meeting. It looked like we would. I think we had maybe 1 or 2 people absent. We would like to go ahead and have the April 15th meeting. That would be the day we would bring back the wireless communication discussion that we had previously, and hoping that we can still get to council in May with that discussion by bringing it back in April. But if we came back in late April, that might jeopardize coming to council in May.
Thank you. Is there anybody, so Commissioner Riggs told us he was not available that date. Is there anyone else who's not available?
I might be out.
Okay, so Commissioner Alchek mentioned that he may have travel plans already scheduled.
I might be out too, but
Okay.
I might be out too, but I'll let you know.
When, I guess, we'll know when you know.
Without me.
Yeah, if there were only, if 4 commissioners will be here, we will have a quorum.
Okay, okay. All right,
that's
great,
okay.
thank you. All right, is there anything else? All right, thank you all so much. This meeting is adjourned at 8:49. Thank you.